All right, good afternoon. What a nice crowd for a Thursday afternoon. I'm Michael Scharf. I'm the co-dean at the law school, and it is my great pleasure to welcome you to this event on behalf of the faculty and the whole law school community. We have a robust lecture series here, and I hope you'll grab one of the lecture brochures because there's much coming up in the next couple of weeks. Our faculty has been very involved in getting these lecturers, and our faculty themselves are lecturing around the country. You may not know this, but we have the 25th best ranked faculty in the United States according to the recent CISC study. We're very excited about that. Thank you. Now, this lecture is hosted by the Center for Cyberspace Law and Policy, which is directed by our own Professor Ray Koo, who's right there. And you'll hear from Ray later in the event. And this event is also co-sponsored by our Journal of Law, Technology, and the Internet. The Center for Cyberspace Law and Policy is devoted to studying the creation, dissemination, and acquisition of human thought, creativity, and information in the digital age. And the Journal of Law, Technology, and the Internet, which we call JOLTI, is published by the students of Case Western Reserve University School of Law, and it focuses on emerging legal issues brought forward by developing technologies. JOLTI will be publishing today's speech by Professor Anupam Chander, and it'll be in the 7th edition. Now, we have the editor-in-chief of JOLTI with us, and he is going to introduce our speaker today, and you are all in for a big treat. So if Stephen Congdon could come down, I will turn over the floor to you. Thank you, Stephen.
Thank you, Dean Scharf, for that introduction. On behalf of Case Western Reserve University School of Law, Center for Cyberspace, Law and Policy, and the Journal of Law, Technology, and the Internet, I am pleased to welcome you all to our lecture series today. Today's speaker is University of California, Davis's School of Law professor, Anupam Chander. Professor Chander serves as the Martin Luther King Jr. Hall Research Scholar at UC Davis and is the director of the California International Law Center. A graduate of Harvard College and Yale Law School, Professor Chander has been a visiting professor at Yale, Chicago, Stanford, and Cornell. His book, The Electronic Silk Road, was published by Yale Press in 2014, and Professor Chander's work has been published widely in the nation's leading law journals. Professor Chander has practiced law in both New York and Hong Kong with Cleary, Gottlieb, Steen, and Hamilton. He served on the Executive Council of the American Society of International Law and serves as a judge for the Stanford Junior International Faculty Forum. Professor Chander is a recipient of Google Research Awards and an Andrew Mellon Grant on the topic of surveillance, and is also a member of the International Center for Trade and Sustainable Development and World Economic Forum's expert group on the digital economy. We thank Professor Chander very much for joining us here today, and please all of you join me in welcoming Professor Chander for our speech.
It's a delight to be here. I actually grew up in Ohio, in the southwestern part of Ohio, so it's always a pleasure to come back to my home state. So it's not just Black Lives Matter, it's hashtag Black Lives Matter. The hashtag is silent. The protests that swept the nation last year began through Facebook and Twitter, organized via hashtag. The hashtag allowed individuals who didn't know each other by name to learn, share, and debate without requiring any intermediation by the traditional media. The hashtag brought people to the streets and national attention to the problem as old as this country, the differential treatment of African Americans in our justice system. The internet's role in organizing protests, of course, is well understood. But it's worth pausing to note that today's civic engagement increasingly occurs online. Even if we are bowling alone, we're doing so while sharing with friends and family across the world through Instagram, WeChat, Periscope, Twitter, Weibo, Facebook, etc. Here is a map of my own, this is a picture of my book. Here is a map of my own Twitter followers, for example, which, as you can see, stride the world, right? Most of them concentrated in the United States, but with a very healthy number across the world. So even as we worry about a world in which people increasingly withdraw into their mobile devices, we should recognize that individuals are actually connecting to each other in ways that were heretofore impossible. And they're using it to do things like organize protest and organize new social activities. Now, while it's a commonplace that the internet revolutionized speech, what is perhaps less well understood is that free speech made today's internet. The First Amendment played an essential role in configuring the legal environment that enabled the rise of the internet as we know it today. In the process, helping bring the promise of 1789 closer to fruition. This is what I have labeled the First Amendment cyber law dialectic. The First Amendment made today's cyber law, and cyber law in turn helped make speech free. Some will say, of course, that speech was free long before the internet. Didn't we teach courses about free speech before the internet? But consider the speech that was made free in the case that launched the modern First Amendment. New York Times v. Sullivan. The speech in the case consisted in an ad placed in 1960 in the New York Times. The speakers paid in 1960 $4,800 to communicate a message to the nation. That was what you needed to do if you wanted to communicate to the nation, and you didn't have, say, the New York Times editorial page backing your statement. Speech was hardly free as in cost, and hardly equal as in accessible, regardless of one's economic status. Indeed, in his brief before the court, Commissioner Sullivan, who was the one bringing the defamation claim against the New York Times for being charged, the case, if you'll recall, so I should just mention the case involved a claim by a commissioner in the American South who said this advertisement that runs in the New York Times that says that there is racial discrimination in the criminal justice system in this person's state. That person, the person who was charged with this, and other people who were also accused of being racially unjust, brought a defamation claim against the New York Times. In New York Times v. Sullivan, the Supreme Court said the defamation claim could not stand because this was a matter in the public interest. And there was no malice on the part of the New York Times. So, Commissioner Sullivan, in defense of against the New York Times free speech claim, argued that the New York Times claimed to be promoting, quote, the equality of practical enjoyment of the benefits was ridiculous. How could there be a practical enjoyment of the benefits of taking out a $4,800 ad in the New York Times? And he was right. So when this week, Governor Jeb Bush tweeted a photo that said, that had a photo of his gun engraved with his name on it, under the caption, America, Americans responded. Many signaled their approval. So they hearted it. So like 25,000 or so gave it the Twitter version of a like. Many retweeted his tweet. And as if you do Twitter, you understand that retweeting is not necessarily endorsement, so it's harder to know what retweeting means. But yet others responded directly to the claim. And they often, as has been noted across the media, made very clever and reposts to the claim. My favorite is, there's a ton that are my favorite. It's a picture of a teacup with it says the UK. All right. There's, for Australia, someone posted a Nerf gun. So this is a medium in which people are now able to engage directly the leaders of this country. They're able to engage them in a way that was impossible before, to have their thoughts shared, tweeted, retweeted, hearted across the world. In recent years, we've seen many arguments for the signal success of Silicon Valley. It will be said that it was the confluence of money and education that led to a successful agglomeration in Silicon Valley. It was the culture of Silicon Valley. Indeed, many moved to Silicon Valley from across the world to access venture capital and local talent. So if you want to set up a new startup, you might well move first to Silicon Valley. That's what Mark Zuckerberg did, right? But I want to argue that the traditional explanations are all incomplete. It was the First Amendment's disciplining of private law that proved to be the key feature of success for American internet enterprise in the 1990s and the 2000s. As Ray Koo has described in a highly influential article, the internet brought about radically different distribution mechanisms. This was clear at the end of the 1990s. But rather than rely on individuals to put up web servers and web pages themselves, the most successful distribution mechanisms were those that created new social networks. Those relied on information intermediaries, creating what came to be known as Web 2.0. So Web 1.0 you can picture as individuals going out and putting up a website, a very cumbersome process. And Web 2.0 you can imagine as putting up a photo of a teacup on Twitter, or posting a picture of this event on Facebook or Instagram, etc. Return to the traditional explanations for Silicon Valley's success in the internet age. Certainly, there's no better place across the world to obtain venture capital than Silicon Valley. But this reflects a history of success of prior investments, thereby encouraging more venture capital to come to Silicon Valley. Venture capital thrived in California because pouring money into loss-making speculative enterprises run by 20-somethings who might be college dropouts proved successful time and time again, defying all reason. These ventures depended not on large infrastructures, but on individuals across the world contributing labor and content for free. And this in turn depended on laws that made the ventures activities legal, specifically insulated them from civil liability for the wrongs of their users. Now, turn to the cultural explanation. The culture of Silicon Valley prizes innovation and bold ideas that carry the hubris of changing the world. Failure in a past venture is but prelude to a future success. Again, this boldness in confronting the world and nonchalance about failure arises through a recent history of success. That is, others have boldly and successfully confronted the world. Others have survived failure to create new and successful enterprise. And again, these successes would not have been possible without an encouraging law. Finally, the talent pool in Silicon Valley, indeed the envy of the world. But walking into a cafeteria at Google is like walking into the United Nations itself. I love this photo. Michael has kindly left this flag up for me. Silicon Valley became a magnet for success for people across the world because of its prior success. People continue to move there, driving prices of real estate up to astronomical levels. There was a moment this last fall where someone was offering up a tent on his lawn on Craigslist in Silicon Valley for a few $100s a night. If the companies had failed because of law that was unwelcoming, the venture capital and talent would have dried up, and the culture shifted to one that was more risk-averse. So the law provided the foundation for moving from Web 1.0 to Web 2.0. Now, how did it do this? The First Amendment protected internet intermediaries from obligations to censor, while at the same time rebuffing efforts to impose strict privacy obligations on internet enterprise. The First Amendment thus created a business model of new media, permitting it to publish vast amounts of speech, but not be held liable for that speech, while at the same time earning income not through subscriptions, but rather advertising based on personal profiling. This ad is better directed to you because we know what you like. For the first time now, so there's a rich result. Individuals can now speak to the nation through YouTube, Twitter, blogs, comments, Facebook, and Google without needing either princely sums for national advertising or the permission of editors. And as we move from Web 2.0, so Web 2.0 is a thing of the past already, as Silicon Valley imagines Web 3.0 in the future, and actually the new buzzword is Industry 4.0. So I'm not sure what Industry 3.0 was, but it's already Industry 4.0, and it's INDSTURIE 4.0. As we imagine the future, as we move to a platform economy, we should keep some of these lessons in mind. After all, platforms such as Uber and Airbnb are also fundamentally search and communications engines, allowing individuals to find and communicate with each other on a spot basis. So, as this is a legal crowd, let me focus a little bit more specifically on the law. And here I've put up here, on the slide behind me, I don't expect you to turn around. I've put up a little sketch, a thumbnail of some of the legal issues. In 1996, Congress recognized the internet as a forum for a true diversity of political discourse, unique opportunities for cultural development, and myriad avenues for intellectual activity. I'm reading the purpose recital in the Communications Decency Act of that year. The Communications Decency Act established that no provider of an internet service could be held liable for the content posted by its users. Okay, so this is very different, for example, than what the liabilities of the New York Times for what is on its print version. The New York Times is liable for the letters to the editor, right? This law said if you have a NewYorkTimes.com, it's not liable for information provided by all letter writers to its service. And this is true of Facebook and Twitter and all similar activities. So I want to then mention copyright. Before I do that. So a similar move was made in the DMCA, the Digital Millennium Copyright Act in 1998, with in Title II, which created a safe harbor for copyright infringement if the internet service provider, the content host, would take down material upon notice. Okay. And third, enforcement of privacy policies as opposed to new privacy laws, and I'll get back to the privacy issues shortly. This created what the Supreme Court called in 1997 the vast democratic forums of the internet. And this created what I claim the foundation for enterprises like Facebook, even Amazon, or Pinterest. Facebook, as you know, allows you to post whatever you want. It doesn't ask, where did this image come from? Where did this text come from? Where did this video come from? Just post away. And again, that's possible because of Section 230, and it's possible because of DMCA Title II. In fact, this has led within Facebook to something that has been dubbed Zuckerberg's Law. And we're apparently living in Zuckerberg's Law. Ask yourself if this is the case about yourself. Sorry. Here. Okay, we may not be able to see it. Let's see. Sorry. Zuckerberg's Law is the idea that every year you will share twice as much information as you shared the year before. Okay. But consider Amazon. Amazon's, one of its huge advantages against the world, one of its signal properties, is its review system, which gives you the right to fill a box of whatever you want, not just to rate something, but to fill a box. Imagine the possibilities for defamation and gamesmanship in this context. You have a competitor book, well, you defame, you say this other book is based on lies and falsehoods, right? Pretty obvious that, and Amazon does it check to see whether you bought the book or the item? No. Amazon is very keen to have your review. No questions asked, right? And Amazon was sued, of course, right? Because inevitably someone will feel that they were defamed by the review. How many people who are book authors haven't felt defamed by some review? I certainly have. I have a book. I felt, defamed by the, not really legally defamed, but, unjustly, criticized, right? That's what it means to be an author. Jerome Snyder sued Amazon for what he believed to be defamation. Amazon didn't remove the statements. And the Washington Appeals Court held that he was protected by the Section 230. If Amazon were required to take down the review that an author considered defamatory, imagine a system where an author would just send you notice, I think that's defamatory, okay? And you take down that notice. I got a 4-star review rather than a 5-star review for my book. I would like that taken down because it's, I'd like a perfect 5, right? What would Amazon do? If there was a notice and takedown liability regime, it would take it down. Because there's no legal incentive, there's no economic damage for taking down bad things. The damage only lies if you leave something bad up. Okay, right? So in this context, a notice and takedown regime would mean that anytime someone felt that something was negative about him or her, that person would just send a notice and it would disappear because the economic interests of the intermediary would be to get rid of that information. Okay, so I went and looked at what is going on with Jerome Snyder today. Here is the one review of his book that exists today. It must be the same person. And this one says, the author was recently convicted of defrauding the United States government. That's the review still up. Amazon is still leaving it standing. You can sue me, but we're still gonna leave it up. But ask yourself, how does Amazon know whether this is true? If you're the inside counsel at Amazon, how do you know whether the author was or wasn't convicted of defrauding the government, right? There's no simple way for Amazon to know. If you had a notice and takedown liability scheme, you would remove it. That would be your advice as legal counsel. So that's Zuckerberg's Law. It's, I just had timed it slightly differently. Okay. Now think about Pinterest. How many of you here use Pinterest? Okay, so Pinterest is this amazing service, right? What it is essentially is a huge copying machine for the web. Okay, you go around the web, say, I like this, boom, it and it appears on your page. I like this, boom, appears on your page. It's a massive copying machine for the web, right? Now, normally, a lawyer might say, hey, you're abetting copyright infringement, right? That would be your first impulse as a lawyer. You just created a tool that makes it super easy. Do you ask first, Pinterestable? No, there's no tag necessary, right? Anything, you don't look at the licensing, is this public domain, et cetera. I'm just copying that, right? So Pinterest is a huge copying machine. So in 2013, Pinterest gets a $100 million investment by the Japanese firm Rakuten, 2012, I'm sorry. Pinterest has no significant technology. It's not a technological marvel, okay? It's simply an idea that can be executed by tons and tons of programmers, okay? Why does this Japanese firm invest $100 million in an American company that's doing this? Because it would be illegal for the Japanese firm to do it at home, okay? And you can still offer Pinterest in Japan, but do it through this American company, not a Japanese company. Okay, so a couple notes in this. Free expression and robust debate require the right to criticize others, not just to sing their praises. So one of the negatives about this, which I'll get to, is that, look, we've just immunized Amazon for allegedly defamatory material. I don't know if it was defamatory or not, right? That material could be defamatory. It's still up today, right? Of course, it hasn't been challenged. Of course, you could go after, Jerome Snyder could sue Roger, whoever it was, directly and prove that it was defamatory, and then it would come down, right? That would be the legal process. But Amazon is removed from intermediating that question, okay? Amazon does not sit as judge or jury in that question. Amazon can remain aloof from that query because of the law. The end result is that this supports both free speech, including the right to say negative things about people. Give my book a 4-star rating, damn it, rather than what it deserves, a 5-star rating, or, which is part of free speech, right? And support economic development. Why? You lead investments like a $100 million investment from a Japanese firm into the United States. U.S., and a fundamental point here is that the U.S.-based startups attract venture capital because their business model is legal here, and uniquely here. Okay. And this leads to things, wonderful ideas like Alex McGillivray, then general counsel of Twitter. We are the free speech wing of the free speech party, right? Now, you may think this is all foregone. This is the way it had to be because of the First Amendment. And maybe that's the case, maybe not. But I want to just pause to, when I was doing the reading through the congressional record and looking for what was going on in the debates, I stumbled upon this wonderful colloquy. Ron Wyden, who was one of the champions of internet enterprise, really kind of a huge hero for internet companies today. I yield a moment to the gentlewoman from Missouri, Ms. Danner. Sorry, let's see if we can read this. Mr. Chairman, I strongly support the gentleman's efforts to address the problem of having children having untraceable access through online computer services to inappropriate material. Telephone companies inform us as to whom our long-distance calls are made to. This was a long time ago. The young people, the students here won't remember, but the old folks like me remember when you got your itemized bill giving you all the phone numbers you'd called and how long each call was. I believe that if computer online services were made to include itemized billing, it would be a practical solution to inform parents as to what materials their children are accessing on the internet. So at this point in the House, you're seeing someone propose Itemized billing, that is, telling you exactly a list of all the URLs visited. Okay, so so that's what this Congresswoman was proposing. That didn't come to pass. Okay, so I've described the United States, and I've said it had a uniquely hospitable environment. So I want to turn briefly, kind of again, thumbnail, to two other jurisdictions. I'm turning to the European Union and then to Japan. Okay, I'm mindful of the time here. The European Union approach. The European Union approach, instead of limiting liability for intermediaries, it actually created exposure for intermediaries. So, more uncertain intermediary liability rules. Even while disavowing any duty to monitor, it said there might be duties of care. Duties of care is a very uncertain phraseology. You don't know exactly what it means to be careful, right? What do I have to do is that, okay, I don't have to monitor what's happening in my system, but what's my duty of care? What does it entail? And stricter copyright. There's a wonderful statement by Prime Minister David Cameron. He said, the heads of Google, Larry and Sergey, told me that they couldn't have built Google in the UK. Okay, and this wasn't because of money or talent, okay, in the UK, but rather because of its strict copyright law. So Google, he said, they told him, was basically had to copy the internet in order to search, in order to create a search index. And in the United States, Google felt that there was fair use that would protect them from being seen as infringers because of this copying activity involved in their search indexing function. And he cited this as an important feature of US law that allowed Google to thrive in the United States and not in the UK. So that, by the way, it may not be the case that Larry and Sergey actually told him this. He says they told him this, but there's some question as to whether or not they actually told him this, all right? And strict privacy rules. And I just want to give you a brief introduction to a case called Bodil Lindqvist v. Aklagarkamaran i Jönköping in the European Court of Justice. In Sweden, a woman takes a data processing class, okay, which is basically just learning how to put up a web page. Okay. In this process, she puts up a web page that describes her fellow parishioners. Okay. Nothing negative. But in one of the things it says someone so and so has hurt his or her leg. Okay. Not ridiculing the person. There's nothing negative about this. For this, she is criminally prosecuted. I'm not kidding. This is not this goes then from the Swedish court to the European Court of Justice, the highest court in the European constitutional structure, where the question is, has she violated data protection law or privacy law in putting up a web page without asking their individual permission? And by the way, she's done even the worst thing, which is release medical information without their consent. Okay, the most sensitive information. Someone hurt their leg. Okay, and the answer of the European Court of Justice, throwing this out? No, the answer of the European Court of Justice, yes. Highly sensitive information, data processing breach, criminal liability lies. Luckily, in the liability regime is just a fine, and the fine, by the way, just interestingly, is based on your income. It's a very interesting calculation. Okay, and think about the right to be forgotten. And I'm just going to I'll just skip this for now, but we can talk about it. The end result is that it's futile. It undermines free expression. And it's friendly fire and local innovation. You can't create these kinds of new enterprises within the European space. And the companies that try are typically the ones that are heavily, that are large telecom companies currently, okay, which have huge amounts of capital investment that they can offer up, not the fledgling startups common to Silicon Valley. Okay, now go to Japan, and I'm just going to take one data point from here. In 2004, Isamu Kaneko was arrested for distributing a kind of Napster-like file sharing service. He was arrested, okay? You know, the guys behind Napster, you know, they went through a lot of court hassle, certainly. There's a lot of civil liabilities that were, you know, that they had to face. And they did it all pre, you know, the DMCA protections, or not taking advantage of the DMCA protections. In Japan, this program at the University of Tokyo is arrested for distributing a similar system. Okay. The court admitted that Kaneko had not specifically intended to cause copyright violation. He didn't intend to procure any financial gain. Okay, note that, I'll come back to that. But as he had continued to make available the Winnie program to the public on the internet, despite recognizing it was used for copyright infringement, the court criticized his attitude as selfish and irresponsible. He was finally cleared. So in 2004, this is the initial district court ruling. He was finally cleared in 2011 by the Japanese Supreme Court. But that's how long it took to fight this claim of distributing a piece of software that allows people to distribute whatever they want, right? And so he's criminally arrested. And so, you know, I have a quote in the paper which says, essentially, a computer science professor saying to his students, I tell my students, release your software overseas. In 2009, Google's Fumi Yamazaki wrote, did you know that running a search engine index server in Japan is illegal in Japan? Again, because of copyright law. Okay, so where are these enterprises going to develop? Are they going to develop in these places that make it illegal to do the things that are commonplace in Silicon Valley? All right, in sum, where the US approached the internet with hope, the rest of the world approached it with fear. The end result is that with contemporary communication technologies, free speech becomes then an industrial policy. All right, now there will be criticisms, and I just want to anticipate a few criticisms. Slacktivism, echo chamber, manipulation, hate speech, Skynet. So let me just briefly mention all these. Okay, so let's see if I can do this. Oh, if the mouse is sorry, which one is it? I just wanted to use the mouse if I could. Oh, can I just, unfortunately it's all right, I can just skip that. All right, so the first one is slacktivism. So let me just talk about the slacktivism concern. Clearly, it's the case that just internet-like or an internet heart or a retweet does not by itself accomplish change. Right? I think that's clearly the case. But at the same time, we have to understand that it's increasingly a crucial part of achieving change. Even though itself may seem inconsequential, the fact that numerous people are collaborating and supporting each other online means that other people actually take to the streets, show up, and demand change. Right? So the slacktivism, which seems ineffectual, in fact is part of an ecosystem that contributes to actual change. So, and we saw this with the Egyptian and the revolutions across northern Africa, which began largely, they began on the street, but then they were organized online, allowing them then to create huge amounts of protests around special events. Echo chamber, and this is a common complaint about the internet. And there's certainly some truth to the fact that people can cocoon themselves from other information sources online, right? If you're right or left, you can choose only right or left information sources. But the reality is that even if you're getting right or left information services, there's many places where people actually cross borders. For example, on Facebook. Just yesterday, I have someone who is a Marxist, Brian Leiter at Chicago, versus someone who is supporting Bernie Sanders, versus someone who is, a right-winger supporting Donald Trump, potentially supporting Donald Trump, a professor at UCLA, on my Facebook wall, arguing about these things, right? So I think if you have a Facebook wall that doesn't have any argument, that's because you're avoiding all argument, and everyone that you know is avoiding all argument. But the reality is that many people have Facebook walls or other information sources that are full of people debating each other online. Now, I know that the comments section of any web page are ones that you typically, that many people find to be a cesspool, but in fact, it does allow people to communicate, whether or not you like what they say, and most of the time I don't. It is an important vehicle for ordinary people to communicate. Finally, and most importantly, with respect to echo chamber, it's also important to recognize what came before the internet, what the pre-internet world looked like. And that was a world in which there were just a few channels. There was just one local newspaper, maybe two, where the world was really very narrowly restricted. And in fact, it was an echo chamber of a different kind. It was an echo chamber of the people in power, getting to say again and again what they thought should continue to be in power. There was a previous echo chamber. We may have echo chambers today, but they're far more diverse than they were 30 years ago, when the echo chamber was CBS Nightly News, which everyone turned to. Walter Cronkite is on, Dan Rather is on, right? That was a different kind of echo chamber. And we should recognize that as we worry about echo chambers today. Certainly issues of manipulation are important, and I need to end quickly. So issues of preference manipulation, being manipulated to buy things when you're most vulnerable. And I think we need to be watchful of this, and I think that certainly is an important question. As I've already mentioned, this allows for a U.S. Legal regime that tolerates hate speech online. Right? Now, companies themselves could choose to censor, but even companies like Google have a very hard time figuring out what is hate speech and what isn't. Because, the idea, hate speech is a very fuzzy concept. For some people, it's saying the truth, and other people, it's hate speech. And so this is a difficult issue. And so we certainly, does mean that we have tolerated a far more diverse and at times very indecent internet in the process. Finally, I think an important question that arises in this context is the possibility of corporate governmental collaboration, which might be inimical to democracy. That is, if governments know as much about us as corporations know about us, that information could be used in ways that suppress dissent and keep governments in power. Right? So the corporations now, as I've described, know a tremendous amount about us. Every time you do a search, every time you go to a URL, that's a lot of information that's being shared with the entity that you're searching through or the website that you're visiting. That information in the hands of the government is particularly alarming because the government could easily want to continue its existence in power. Right? So I think that is a fundamental, the kind of collaboration to end democracy between corporations and governments is one to be feared. And you see this a little bit in the pushback from Apple yesterday. Right? Apple is saying, we don't want to give this information to you. We don't want to be your assistant in getting information from everyone else. That's not our duty. If you have this iPhone, you can break it if you want, but it's not our duty to assist you in breaking it, right? You can ask questions about that. This is a very tricky question, but there's an impulse that I think Apple rightly has that says we don't want to be too close to providing this information to the government. Okay, so let me end there. I'm happy to take questions and comments. Thank you. Stephen. Yeah.
Did Snyder sue the reviewer?
I do not know. There's no evidence that, given that the review is up, that he did. But in that case, in the case that was against Amazon, it was the case against Amazon, not the reviewer. Maybe because the reviewer was anonymous in some sense, but. So you can, by the way, pierce anonymity online, so there are legal processes that you can do to get through to the ultimate person who actually posted something. That's difficult to do. It's not always 100% effective, but it does happen. In the Amazon case, that's not described. A suit against against the actual reviewer himself or herself.
So you gave the example about the UK, the woman who made her own website. Do you feel like the UK has a better way of dealing with internet sex crimes than the US? For example, the recent case where all the celebrities, their computers were hacked and the pictures of them were posted online.
Right. So the case I described was actually from Sweden, the Bodo Lindqvist, very Swedish name. Does Europe in general have better sex crime laws with respect to internet activities? I'm not sure. And I don't know enough about the European rules in this way. And certainly we've had a lot of celebrities who've had their information hacked, et cetera. So in the United States, so that's and others as well, not just European, not just celebrities. I think I would say we do have laws in place that, like the Computer Fraud and Abuse Act, which obviously are targeted towards that kind of hacking. So they may be hard to enforce because, in general, computer crime is difficult. But we've seen that the U.S. government, you saw in the Pirate Bay case, an extraordinary success story from the U.S. government enforcing against the dark web, which many people thought entirely outside the capacity of government to actually attend to. And they tracked down this guy who turned out to be a young 20-something living, of course, in where else would you do a startup? In San Francisco. It was a dark web startup that was selling drugs online and anything illegal online. But he ran it from San Francisco. They found him oddly enough, this is such a great story. They found him, the FBI found him in the San Francisco Public Library. So that's where he was. So I think in general, we have laws, and it's a question of enforcing them. And I think we have shown that we have been successful at times, unsuccessful at times. Obviously, there was the Sony hack, which was one of these huge hacks. There's the Office of Personnel Management hack, which is still ongoing investigation. Where we've had hacks that the perpetrators we've thought were offshore, and we have no way to really assert jurisdiction over them.
Okay, I'm back to the question where your rival or your customer is putting defamatory information and the provider or the platform seems to be immune. Could the the aggrieved party, put the platform on notice with some sort of a communication saying, this is what I say, and I'm swearing to it?
And that's what Snyder tried. Snyder said, I told you that this is defamatory, and you refused to take it down. And Amazon said, go ahead and sue us. And Amazon showed up in court and defended itself and still won.
So there's no remedy for somebody who's...
Well, his remedy is the remedy that this gentleman asked about earlier, suing the actual reviewer. And of course, you have to pierce, if it's anonymously done, you have to pierce the anonymity through a legal process.
It stays up forever.
Well,
Unless you can win.
yeah, no, you're right that it's this is the cost of that, right? But there's so you're absolutely right, but we don't know. I don't know to this day whether or not Mr. Snyder was convicted of a federal offense. Now it seems unlikely, but who knows?
In this case, he gets his money to any cent of argument.
Yeah, I think that's not an issue. Then Amazon would clearly take it down. I think it would do it as a matter of policy. Now, is it legally obligated to do so, even if it knows the truth? That's a really good question. I don't think so. But it's a good legal question. I think it certainly would. I think if you sent the court judgment that this was defamation and it showed this, Amazon would take it down. So I don't think that case has been tested because the facts aren't going to arise, right? You'd have to be a really foolish company to want to test that question.
So part of my question, I guess, under Section 230, nothing would stop, though, Amazon or a company from removing that by their own discretion, right? And in fact, it protects them from doing so.
And that's I should say this, that one of the goals of 230 is to create self-monitoring regimes, so you can clean up the internet how you like and be assured that your removing information from cyberspace is not going to subject you to liability.
Right. So there is that corrective. I guess then it touches, though, on a concern that I think you mentioned near the end of your remarks, which is that, your title could just as easily be how Silicon Valley makes the law, makes the First Amendment, right? And so the concern that to the extent our discourse, so much public discourse is actually through these intermediaries today, it is Facebook's discretionary actions, it is Google's, whomever's, in terms of what they deem offensive, what they deem not offensive, that they take down. How do you feel about that?
That's a great question. So I just want to go back to the 1990s, though. So the question of Silicon Valley making the law. Think about the 1990s and the DMCA, the Digital Millennium Copyright Act. Who's powerful in the halls of Congress? Is it the upstarts of Yahoo and AOL? No, it's the Hollywood motion picture industry, right? And Hollywood wanted intermediary liability for copyright infringement. It did not want a safe harbor system for copyright infringement, etc. It wanted the common law, actually. It wanted Congress not to legislate in the area at all, right? And in fact, there was this deal reached, despite the fact that the well-heeled interests were the ones, at the time, were arguing against creating any kind of immunity regime for copyright, right? So this is not just a simple story of the people with the money get the law written for them, right? And so what I'm trying to say is that here, it was the First Amendment that did a lot of work. And so it actually it disciplined, a heavy-handed IP regime, right? So fair use has, First Amendment foundations, and Ray has written about the relationship of the copyright and the First Amendment. And so there's even with strong economic interests at issue, there are important ways to think that there are values that Congress might entertain and actually put into effect. I'm going to go on. There's more I could say, but given the time and I have a number of hands.
Over here. I have a question, though, about the users of the platforms. And and the actual use of such things as the Amazon reviewers or Yelp being an effective business tool, is the use of these sites outstripping the law as it exists now? Because as the users rely on it, are the users becoming more sophisticated and doing their own self-censorship or self-analysis of the reviews that make the laws almost obsolete at this point?
I think you are seeing a lot of, sophistication, increasing sophistication online. How many people here use Amazon reviews? Right? So despite the fact of all this gamesmanship, all the fact that you know that people are lying and reviewing things and having their friend or whatever review it, you still find it useful. You still take the time to read them, right? And it turns out that it is useful. And you look at the content of it, is it persuasive? You weigh it and you make a judgment, right? And I think it turns out that these systems have been relatively successful, as attested to by a very sophisticated audience that reads reviews written anonymously often, right? Written by people you don't know. And you look at how many and what's the content. You do that kind of evaluation. Is this a reliable review? And of course, you know that at the end of the day, it may not be 100% correct, but it's certainly better than information sources that you had before, right? So it created a richness of information about the world that we didn't have 30 years ago.
You've framed the discussion in a way as being hope versus fear. Couldn't it have also been framed as pillage versus respect? By pillage, I mean, under the America schema, we have nationalized and privatized not only our online reputations, but also our psyche. Now, the solution may be, in fact, all those really smart people in Silicon Valley with all that money that's flooded there based upon all their successes may have a private sector solution. What I wonder then is whether the America legal scheme has precluded those smart people and all that money developing mechanisms by which our psyche can be protected by anonymizing our online interactions and transactions.
So you could go through anonymous sources, right, systems, but it turns out that the one system that, I'm sure that most of you don't use Twitter, which can be anonymous, by the way, but you use, I bet you that most of the people, how many people here use Twitter? How many people here use Facebook? And Facebook is not the anonymous one, right? Facebook is the one where people are forced to use their real name. So it turns out that people like Facebook. I'm not saying that, I like the fact there's diversity of things, and let people choose what they want to use or not, right? So I think that's true. As respect to, to begin your wonderful phrase, pillage or respect, let me respond quickly to that. In Facebook's headquarters, there is a saying that Mark Zuckerberg has that he's plastered, which is move fast and break things. Okay, right? So the idea is to innovate fast, to really figure out, what people want, sometimes get it wrong, okay, but then recalibrating again and again and again, trying to give people, anticipate what people want, trying to create new and different things. Every time, if you look back at the history of Facebook, and I've done this, every change they've made, people have screamed bloody murder, okay, all right, and yet you use it today. Okay, this is going on with Twitter, by the way. Twitter just moved to an algorithmic feed, but the same, I don't think Twitter's usage has gone down. It moved, by the way, Twitter changed to a heart instead of a star, and people thought that was going to be the end of Twitter and everything like that. So things change, and maybe the public says we don't want it, but sometimes the public says we want it, right? And so I appreciate the fact that there's innovation. It does mean that there is a price to pay, and I think it's important to recognize the price. I'm not saying that we shouldn't recognize the price, but the question is how you strike the balance that wouldn't be there are people who argue that we should stop these companies from collecting information. How do you stop companies from collecting information for marketing purposes? That seems fundamentally antithetical to a free speech environment. So it's very hard to write a law that says you can't collect information for marketing purposes, okay? Just because you're doing it online. Right? That's what some people would like. How do you write that law without suppressing wide swaths of speech? And there's the price that would be paid by, making sure that you've respected everyone's concerns fully and not hurt people's psyche in the process. I think would be too heavy a price in a country that does believe in speech, that allows the Nazis to march in Skokie, to insult huge numbers of people, right? That's the price that we have as a society been willing to tolerate. You can ask yourself whether or not that's a price that we should pay. But my point here is, one, it has created a very robust speech system, and two, it's had the incidental effect, not the intentional effect, of creating a very robust economic system, right? This gentleman right here has been holding his hand up. No, right here, yeah, in the jacket.
So I think you sort of mentioned that a lot of both the EU and Japan to some extent are at least conscious that their current internet policies are inimical to, business growth or...
I'm not sure they're conscious of this, I'm sorry. I disagree.
Okay, well...
It should be obvious, I'm sorry. David Cameron has suggested this in this tiny way, but overall the EU goes further down this line. Overall, Japan continues down this line. It's not, my goal is to pull the wool out of people's eyes, yeah.
So I guess then you've noticed, or you haven't seen any sort of change within those legal schemes to come closer to what the U.S. system is?
I have. I mean, that's probably not fair. What I interrupted, in 2011, Isamu Kuneko was cleared after nearly a decade of fighting in the Japanese courts, right? And you see this again and again. There are things that have happened that have reduced, that have ultimately the company has been cleared after lots and lots of legal wrangling. I know that we need to end, so I should probably pause here. I realize that you guys are off to other things as well. So, thank you.